5, 4. Order. Welcome to today's special hearing on arms exports to Israel. Understanding Order 152 is the responsibility of this committee to oversee the work of the Department for Business and Trade, and arms export licensing is part of the DBT's policy area. This area of policy was formally scrutinised by a joint committee which struggled to be quorate. It issued just 2 reports in the last 4.5 years. And so in January those arrangements were dissolved and this committee assumed oversight of scrutiny of strategic export licences. Since January we have begun our work of scrutiny, and in the light of the ECJ's provisional findings we thought it was important that we begin bringing together evidence in order to inform Parliament and to ensure that parliamentary debates that follow from these hearings are as well informed as possible about the legal questions in play and the decisions that ministers have taken. So, if I may, Lord Sumption, just kick off with you. Could you just tell us why, in your view, having signed the letter from a number of lawyers, you believe that the UK government should now be suspending strategic export licences?
Well, there are 2 areas of international law which are relevant. One is international humanitarian law, which is in the process of becoming part of customary law, and the other is the International Genocide Convention. The Genocide Convention, which was the main line of argument in the letter that I signed, is important because it engages the responsibility of non-parties to the relevant conflict. It requires states who are party to the convention, including the UK, to, quote, prevent and punish genocide. And those have been held by the ICJ in previous cases as being completely distinct obligations, prevent and punish. And the prevent part of it is a preemptive position. In other words, it is directed to prospective as well as actual genocide, and it is also directed to suspected, plausibly suspected genocide, and not simply genocide that has been established as a fact. There is a very well-known decision of the International Court of Justice which deals in some detail with the obligations of non-parties to the conflict. It's the Bosnia and Serbia case in 2007. And that basically establishes that all signatories to the convention have a responsibility to take measures within their power which might contribute to preventing genocide. It's irrelevant, they said, that measures available to a signatory would not have been enough to prevent genocide. Essentially, one needs to do what one can, even if that is not a great deal. And that obligation, they said, comes into force whenever the signatory knows or should know that there is a serious risk of genocide, even if it has not yet happened and has not yet been proved. They may therefore have no certainty in order that this obligation should be triggered. Now, the interim judgment of the ICJ on the 26th of January, basically the critical parts are the parts that really begin at paragraph 45. Essentially, they started by looking at the facts as they provisionally appeared to be. These are not definitive findings, but they are provisional findings based on material available. And they found, first of all, that the Palestinians were a distinct group entitled to protection. Secondly, that the scale of loss and of life and damage to buildings, they made provisional findings about that based on the evidence given by the reports of UN agencies and the World Health Organization. They then went on to cite evidence of genocidal intent, consisting essentially of statements by the Israeli Defense Minister and the President of Israel, Mr. Herzog, some of which take one aback by the intensity of the hatred that they disclose for the people of Gaza. But the critical finding then follows, paragraph 54, that the facts and circumstances mentioned above, they say, and that's a reference to what I've just been summarising, are sufficient to conclude that at least some of the rights claimed by South Africa, for which it's seeking protection, are plausible. Now, that's a conclusion based on the facts and circumstances above. It is, I think, being suggested in the letter that was subsequently sent by Lawyers for Israel that all that the ICJ was doing was accepting as a matter of abstract law that the inhabitants of Gaza had a right not to be subjected to genocide. I have to say that I regard that proposition as really barely arguable. It seems to me absolutely clear that it was a conclusion based on a combination of the interpretation, well-established interpretation of the Genocide Convention and the facts as they provisionally appeared to be.
Natasha Hausdorff, I'm going to come to you with the same questions, but I'm just going to step through a couple more with Lord Sumption first, which I'm then going to put to you as well. Lord Sumption, based on that argument that you have given us today, what is the risk that the UK government could be taken to the ICJ and successfully prosecuted if it does not suspend strategic export licences today?
Well, that is in part dependent on the politics, in the broad sense of the word, of international tribunals. I think it's unlikely that the UK government, given the relatively small scale of its involvement in the arms trade to Israel, would find itself at the receiving end of proceedings in the ICJ. But I have to say that I, and I assume the other signatories of the letter, have proceeded on the basis that the UK government would wish to comply with its international obligations and not simply to avoid a situation in which its non-compliance was brought before the ICJ.
And at the core of your argument would appear to be your interpretation of this phrase around plausible risk.
Yes.
And you have a different interpretation of plausible risk to the argument that was rehearsed in the letter from UK Lawyers for Israel.
Well, I think the difference is as to whether that phrase is referring to the facts of the current conflict in Gaza, or whether it's referring to the abstract question whether people in Gaza have the right to be protected. That is the essence of the difference, and I've explained why it seems to me perfectly clear.
Just go back over why you believe your interpretation is the correct one.
Because the critical finding of the ICJ in their 26th of January judgment is expressly stated to be based on the facts and circumstances mentioned in the paragraph preceding paragraph 54. And those facts and circumstances are: one, the status of the Gazans as entitled to protection; two, the scale of the conflict and the loss of civilian lives and property; and three, the arguably genocidal intent disclosed by a number of published statements by prominent Israeli government personnel.
Thank you. Natasha Hausdorff, can I please put to you the same question? On the basis of the two letters that you have helped sign, could you just set out for the committee why you believe that strategic export licences should be kept open?
Indeed. In fact, there's been further response, a third letter, if you will, and a fourth also. Those are addressed, and further details provided in a even more detailed response that I've provided to the committee in writing. I'm seeing some nods around, so I understand that's been received by all committee members. And that document not only addresses the legal difference that you, Mr. Chair, have already drawn out, but also the factual inaccuracies which have been contained in the first and third letters. In respect of this issue of plausibility, which is at the very heart of this difference, I think it's extremely important that we're very clear about what the court said on the 26th of January and what the court didn't say. And my noble and learned friend has in fact correctly stated previously the finding of the court in its provisional orders measure. He gave an interview on Sky News a few days after that first letter was circulated, where he stated that the ICJ has not held that Israel's guilty of genocide, but what it has held is that there is a plausible case that the inhabitants of Gaza are entitled to the protection of the Genocide Convention. Now that is critical because it is in contradistinction to the claims of that first letter that there was a plausible risk of genocide in Gaza. I want to be clear at the outset, plausibility at the provisional measures stage of the International Court of Justice is a procedural matter. It is not about the alleged wrong being committed. And the establishment of a prima facie case for the indication of provisional measures rests therefore on a finding that the rights claimed plausibly exist, not that there's been a violation of them, and the case law clearly indicates, as does, I would suggest, the wording adopted by the court itself, that this is about whether or not those rights are essentially subject to a legal determination. Do they fall under the Genocide Convention? Now, it's very important to understand why it is that these allegations of genocide are being advanced. It is not because there is any currency to the allegations, any real evidence to base this on. They've been advanced as a legal hook by South Africa because Israel, as the UK, is a party to the Genocide Convention. That is the basis upon which it has brought Israel to the International Court of Justice. And it's important to understand the origins of these proceedings through that lens when we come on to analyse what it is that the court did in January, which is, of course, supported by its order on the 28th of March. It said it wasn't going to revisit its reasons for the provisional measures. The 9th of April follow-up, so this is the third letter that I referenced, fundamentally also, I'm afraid, misinterprets the necessary conditions for the indication of provisional measures, and this is under Article 41 of the court statute. Now, the plausibility test was first introduced by the court itself as a parameter. This was in the pulp mills case, because provisional measures give rise to obligations on states. And the court needed to satisfy itself, therefore, in the first instance, that there was a plausible case for the existence of the right claimed by the applicant. That was the wording used in pulp mills. And in the obligation to prosecute or extradite case, the court found that the rights asserted by Belgium were plausible because they were grounded in a possible interpretation of the Convention Against Torture. And in the certain activities in the border area case, the court clarified that what was relevant to establish plausibility was only the plausibility of the claim as raised by the requesting party and not the plausibility of any arguments to the contrary. And the reasons behind this are clear when you read the 26th of January order, and I would advocate the merits of doing so. It is not particularly long, and it is clearly expressed. The court did not make any determination of the issues of intention or of the substance of the allegations that South Africa has raised. It was clear that those were issues for the merit stage, which of course come much later in these proceedings. Now, we also include, both in our response letter and I've reiterated it in the detailed response, a summary on how Article 41 of the Statute of the International Court of Justice works from the established commentary. It says that what is at stake in this context is exclusively whether the claim of the applicant is one susceptible to a legal decision, and put plainly, therefore, the existence of whether a prima facie case rests on whether there is a plausible right claimed by the applicant, and the existence of a plausible right essentially rests on whether a claim of the applicant is susceptible to a legal decision. Again, it's not whether a violation has occurred. I would respectfully insist that reading a finding of plausible risk that Israel is committing genocide disregards the court's unambiguous statements, in particular at paragraph 30, where it says it is not required to ascertain whether any violations of Israel's obligations under the Genocide Convention have occurred. The court's task is to establish whether the acts and omissions complained of by the applicant appear to be capable of falling within the provisions of the Genocide Convention. And in the court's view, some of the rights claimed by South Africa were. That is as far as the court went. None of the acts alleged were found to be plausible or likely or arguable or at risk of happening. The real and imminent aspect of the irreparable prejudice that is referred to in later correspondence by the writers of that first letter, this refers to paragraph 74 of the Provisional Measures Order, is crucial for the justification of provisional measures, and it exists as a matter of course wherever genocide or ethnic cleansing is being alleged. So again, that, I'm afraid, does not assist with the inserting of the plausible risk of genocide into these findings. The condition of urgency has always been found on these sorts of cases. However, if the writers of the letter were right, and despite the very clear wording of the court, one were to encourage the committee to read in findings that were not the case. The committee's just been referred to paragraphs, I believe, 45 onwards. Now, that contains several paragraphs of very inaccurate information which has been put before the court. Now, I think it's clear that the court simply didn't factor this into its decision-making with respect to plausibility in any event. But if you are being asked to consider that it did, then I would certainly urge pause and circumspection, because included at paragraph 46 are references to casualty figures which have been serially debunked. This has also been the subject of correspondence from UK Charitable Trust, of which I have the privilege of serving as legal director, to the UK Statistics Authority, because the continual references to some 33,000 casualties now do not even accord with what Hamas, the international believed prescribed terrorist organisation, is claiming. They have indicated about a third of those they don't have identifying information for. And so we're looking inevitably at a much lower, something in the region of 22,000 casualties that are claimed even by this internationally prescribed terrorist organisation. What those casualty figures also do not indicate is any differentiation between civilians and combatants. Now, Israel has been clear that it knows, as of February, it has killed 13,000 terrorist operatives.
Before we go into disputes about the evidence base, let me just bring you back to the question that I put to Lord Sumption, which is, on the basis of your interpretation of the plausibility judgment that was in the ICJ provisional rulings, what is the risk now that the UK is taken to the Hague and successfully prosecuted under the Genocide Convention, in your assessment?
The first thing to be clear about is that the Provisional Measures Order applies between South Africa and Israel. So it does not...
Indeed, but Nicaragua has now, for example, taken Germany to...
Well, indeed. That was the first thing. So it does not, in and of itself, implicate any legal obligations for the United Kingdom. And I think the line that I was elaborating on, so the basis of false information before the court, has certain implications for what legal obligations, if any, might arguably be said to arise. Where I've seen the majority of arguments linking to the UK being put forward is in relation to the UK's general obligation as a signatory to the Genocide Convention, and also separately under Common Article 1 of the Geneva Conventions. And Germany's response to the case brought by Nicaragua is instructive on this. It provided a very comprehensive rebuttal on the issues of complicity. The Bosnia genocide case has been referenced. I mean, it's clear in that case that at least acted knowledge, awareness of the specific intent of the perpetrator was required. There are, I think, very forceful legal arguments that Germany has put forward with respect to the case brought by Nicaragua, which has been criticised for having no legal or factual basis to it, that I would say with relative confidence that case against Germany is unlikely to succeed. Germany also put forward a very robust due diligence defence. However, there is an aspect of this which I would urge the committee to be very mindful of. What we have seen with respect to South Africa's case against Israel, and now Germany and the case brought by Nicaragua is, I would say, lawfare practices of seeking to wage politics through very poorly argued and unsubstantiated cases at the International Court of Justice.
So is the line of argument that there is a low probability that the UK could be taken to The Hague and successfully prosecuted? That's the judgment I'm trying to get from you.
The judgment, I'm afraid, is not necessarily a legal one. It is a political one. In the context of the case that has been brought against Germany, I think the probability of that being in any way successful is negligible. And in that respect, I would expect that outcome to give pause for Nicaragua's threatened cases against anyone else. But statements, including from UK officials and politicians, that present a flawed interpretation of the International Court of Justice's Provisional Order of January, and that suggest, again, without evidence, that the UK government has legal advice that Israel is breaking international law, and others that we have heard making, I'm afraid, unsubstantiated and very problematic assessments, undoubtedly encourage actors like Nicaragua to engage in lawfare, not just against the UK, but against other law-abiding states.
Let's just zero in on the key points of difference. Lord Sumption, based on what you have heard, where would you say the key points of difference in the argument might lie?
Well, there are clearly differences in two areas. One, which I've already addressed, is what the ICJ provisional judgment means. On that, I would simply say that there are two reasons why one might fail the plausibility test. One is that there is no legal basis for it, and the other is that there is no factual basis for it, even on a provisional footing. This particular case was held by the ICJ to satisfy both tests. Now, I don't claim to be an authority on the details of the conflict, but I am impressed by the fact that a court of very considerable prestige has regarded this as a matter which warrants interim measures on the 26th of January, and which does so for reasons which are set out, many of which are factual. Part of my friend's objections seem to be an attack on the way in which the ICJ itself approached it. And since that is the only judgment which has been given so far by any international tribunal on this point, I would be inclined to give greater weight to that than my friend's views about the quality of Nicaragua's case in another proceeding. This is a judgment based on reputable sources, the UN agencies primarily, but also the World Health Organization. And that seems to me to be something that the committee ought to be impressed by, although I would be the first to admit that it is not conclusive.
Natasha, very quick response to that.
Well, just on the casualties point, at least 5 statistical analyses have been carried out by statisticians, data scientists, biomathematicians and economists, including from the Wharton School of the University of Pennsylvania, the Royal Melbourne Institute of Tech, Washington Institute for Near East Policy, that say that the figures, which include those put before the court, do not add up and are likely fabricated or manipulated. And then as I was indicating, since the 10th of April, even Hamas has acknowledged that 1/3 are unsubstantiated by identifying information. I was also indicating that, and it's important that the committee members are alive to this, no distinction is made by this internationally prescribed terrorist organisation between civilians and combatants, and no identification of the manner in which the casualties alleged have come to die. We know that Hamas is bombing its own civilians. We know they've been shooting their own civilians. We know that rockets fired from Gaza towards Israel are also falling short in the Gaza Strip.
Is it fair to say that the argument you're presenting basically rests on one, which is a legal interpretation around the plausibility judgment, and second, a dispute about the evidential base?
Well, as I phrased it earlier, the first and only real issue is the unambiguous application of the plausibility test that the court adopted at the provisional measures stage. This is not new. This is how the court deals with provisional measures. And certainly what I have said is in no way an attack on the International Court of Justice's provisional measures order. I think the fact, and this has been referenced, that provisional measures were ordered is also worth mentioning. Because it's the nature of those provisional measures which also indicate, I think, what the court was doing here. The dissenting judge, the Ugandan judge Sebutinde, called the provisional measures ordered in January redundant. That was because they simply restated the existing international law obligations on Israel, namely to comply with its obligations under the Genocide Convention. The only addition was a report which the Israeli representatives provided to the court within the permitted time frame. And the reason that the key orders being sought by South Africa, namely that Israel be ordered to cease its operation with immediate effect, were not ordered by the court, gives further credence to the only reading unambiguously of the court's determination of plausibility. So that is the primary point. But the reason I reference the inaccuracies, not least because we do so in great detail in the document I've put before the committee, is also because if it were the case that what is being advocated, that the court has actually considered these matters, which would in itself be highly unusual at the provisional measures stage, then it will have done so on a misinformed basis because of these extreme factual inaccuracies. And that is something that would come into play were the original argument credible.
Thank you. Mr. Lavery, did you want to come in at this stage?
I want to just ask with reference to the High Court judgment this week, or the High Court proceedings this week, because documents revealed in the High Court proceedings challenging the export of the UK weapons suggest that the Foreign Secretary Lord Cameron workers with the World Kitchen in Gaza, including, as we all know, 3 British citizens. In weeks on, the matter hasn't been assessed. The court documents also reveal that Israel is not providing the UK government with information on any specific incidents and continues simply to provide assurances after investigating itself. And in this context, can the government comply with the UK arms export regime? And what is the perspective, each of the panellists here, what is your perspective on the UK's ability to uphold its obligations under international law? Lord Ricketts?
Well, thank you. I want to open by saying the legal arguments are fascinating, but I'm absolutely not qualified to address them. I come at this as a mere practitioner, a former practitioner, an observer of what has been going on in Gaza over the last 6 or 8 months, and to come from the legal argument to the concrete nature of the activity on the ground. I entered this fray with an interview on the Today programme, which I thought the time had come for the UK government to suspend arms export licences. It happened to be on the 3rd of April, and within about 3 hours, the letter from the 600 judges and jurists, the first of the letters, was published. And I had actually taken my cue from our own Foreign Secretary, and the increasingly forceful rhetoric that we had heard from the Foreign Secretary in the weeks leading up to that about the situation in Gaza. I was not positioning myself in a debate about whether genocide was occurring or not, but, for example, we in the House of Lords heard from the Foreign Secretary on the 3rd of March about the dreadful suffering in Gaza, the danger of this tipping into famine and danger of illness tipping into disease, and we are now at that point, people are dying of hunger. And then on the radio a few days later, the Foreign Secretary again said, it's incredibly frustrating that Israel was not taking the steps to allow more aid into Gaza amid a terrible humanitarian situation.
He reminded us that Israel is the occupying power and that has responsibilities for the welfare and protection of the civilian population. And whatever the casualty figure, and I think probably we will never know how many people have died in Gaza, and certainly not in what circumstances, since the journalists are more or less completely excluded from Gaza. We've all seen the images of what has been done in hospitals and civilian areas in Gaza, and whatever the casualty figures, they are high, and they include a large number of medical workers and humanitarian workers who, of course, have special protection under international humanitarian law. And I was cued onto this really by the Foreign Secretary saying on the radio that Israel has responsibilities and a judgment will be made, he said, in the coming days on the 8th of March, whether Israel remained compliant with international humanitarian law. So the issue was clearly in play within the government at that point. Then we had the attack on the World Central Kitchen convoy, 7 aid workers killed. It was clearly a deliberate attack on those vehicles because they were badged very clearly. The fact that perhaps Israel had intelligence suggesting there were Hamas combatants, to use your phrase, in the vehicles was clearly wrong, and 7 humanitarian workers died. And that was not an isolated incident. So it was on that basis that I said, as a layman, I thought there was ample evidence at this point for the government to conclude that a suspension of our arms sales to Israel was justified.
Which there is a precedent in August 2014.
Which there is a precedent. And bearing in mind that we are not a major supplier of arms to Israel, my argument is open to the objection it would be a gesture. Another way of putting it would be that we take seriously our published conditions, criteria for supplying arms, which paragraph 2C of our criteria is that the government will judge whether there is a clear risk that the items might be used to commit or facilitate a serious violation of international humanitarian law. That's the bar the government have set themselves, and that's why I said that I thought the time had come to conclude that, recognising that I was a layman, and we've now subsequently had the Foreign Secretary saying in Washington that the government have had a further review of the evidence, and their legal advice shows that they can continue arms supplies for the moment. Okay, fair enough. But I think it was right to put that issue out in public, and that there's been a useful debate afterwards.
Lord Sumption?
I don't think that I can add to what Lord Ricketts has said on that point in answer to your specific question. I agree with him.
You agree with what Lord Ricketts said?
Yes.
Despite the fact that what I have mentioned, what's been revealed in the High Court this week about the fact that the Foreign Secretary and the Business and Trade Secretary agreed to continue with UK arms sales following the incident with regards to the Central Kitchen workers in Gaza, and the fact that the Israeli government are basically marking their own homework. They're not complying with what they need to comply with. They're not supplying the government with the investigation, the details of the investigation of what happened in these instances, which have been absolutely tragic. I think we'll all agree on that. The view is that still think that the government are complying with the UK arms export regime, and also the UK has the ability to uphold its obligations under international law. I'm confused by this, I've got to say.
I don't think, with respect, that what you have just said is at all inconsistent with what Lord Ricketts said a moment ago. That I broadly agree with the points that you have made, and I think that they are essentially the same as the ones that Lord Ricketts has made. The fact is that there has been a lack of discrimination in the Israeli response, which is profoundly troubling and particularly affects the operations of humanitarian agencies like World Kitchen. So I don't actually think that there's a difference here.
Okay.
If I may come in on that, I think the real issue here is that this analysis or pseudo-analysis is being advanced on a worrying false premise, even on the basis of what came out yesterday. The position, as has been articulated by the Divisional Court in the Campaign Against the Arms Trade case, the judgment that came out in the summer of last year, was clear about the ability of the executive to make decisions on export arms licensing privy to information that is simply not in the public domain. It has the advantage of intelligence sharing by the states that are concerned. In this respect, as in that 2023 judgment, which referenced the assessments of the United States that played a role, were a factor in the government's decision-making process vis-à-vis Saudi Arabia, we have had clear indications from the United States that under its assessment, Israel has not violated international humanitarian law. And indeed, at the press conference in Washington, the Foreign Secretary echoed a very similar assessment. With respect to the World Central Kitchen very tragic incident, it's extraordinary to hear this described as a deliberate attack, when Israel has been abundantly clear about the mistaken identification and the regrettable mistake of that strike. Now, this unfortunately happens with respect to all law-abiding states. One only needs to think back to a recent, very well-publicised example in 2021 in the context of the evacuation of Kabul and the US strike on an aid worker and his family. It is not the case, and there is no evidential basis to suggest that Israel's approach has involved a lack of discrimination. Quite the contrary. Israel's consistent upholding of international humanitarian law, the principles of necessity, distinction, proportionality, precaution, have been the subject of detailed analyses through past conflicts, especially in the context of the high-level military group, which I believe the committee has already been referred to their past reports, but also in the context of the current conflict. And that must be discerned from the analysis and the conclusions that have been drawn by the government in this instance. There are a number of other issues that have been raised. The reasons I would stress that the casualty figure inaccuracies are significant is that it is on this basis that these conclusions of indiscriminate attacks or disproportionality are being drawn. Now, not only, I'm afraid, is that legally illiterate in terms of the proportionality principle in international law, which is not about comparing casualty figures. It is very clearly about weighing the anticipated direct concrete military advantage of a strike against the anticipated collateral damage. It is an intention-based analysis. It is not an effects-based analysis. But all of these misrepresentations of international law are essentially feeding the mispremise upon which these conclusions are being drawn. Likewise, reference to famine that has been made. As of last night, there were 650 lorries of humanitarian aid post-inspection by Israel that were awaiting distribution on the border inside Gaza. Since the start of this war in October, there have been 24,018 lorries of humanitarian assistance delivered. That equates to 449,230 tonnes. It is, by the World Food Programme's estimates, 3 times
there's
as much.
Not anything at all to do with the question that I asked, by the
well,
way.
These
nothing at all to do with the question that I did ask.
Well, Ricketts, I think you were just indicating, and actually there is a question for us actually as to how, given the arguments that you've heard, how in government this matter was settled in 2014 and how government should be working today to make a conclusion.
Yes, let me just respond. I'm sorry if I'm legally illiterate, but when I talk about a deliberate strike on the World Central Kitchen convoy, I mean there were 3 vehicles. And images have shown that each was struck with a precision weapon directly on the vehicle. So the Israeli forces intended to attack those vehicles. They clearly did not have accurate intelligence on who was in those vehicles. But that is a pretty critical point. And it may well not be the only case. I think one of the problems the British government has here is it is simply impossible to verify what happens in the tactical engagements that go on constantly in Gaza, often at night, and they've been going on for 6 months. So to say with any confidence that anyone knows what weapon was used, whether conditions of proportionality were met, is extremely difficult. In most conflicts that I've been involved with, the press have been there. Sky News have been reporting from the other side of the front line. Incidents have been very carefully documented. That's not the case in Gaza right now. So there's a great deal of difficulty. On the question of how the government goes about it, I think there was some information disclosed in an action of the High Court, submission by the government to the High Court in December, in response to a campaign against the arms trade case, in which they disclosed that they had set up within the Middle East Department in the Foreign Office a process for examining the evidence and drawing conclusions from it.
We were invited to believe that the Foreign Office did an assessment and sent a recommendation to the Secretary of State for Business, and we're being asked to believe that Number 10 has no input into this decision. As a former National Security Advisor, I would be really interested in your reflections on that decision-making process and whether it's an accurate representation of what could be going on now.
Well, the decision-making process, when I was still in government, I left in 2016, I suspect hasn't changed very much. That is, it's the responsibility of the business secretary, or whatever the title of the job is of the day, and their department to issue licenses and to be accountable to Parliament for that. And they do that on the basis of advice from the Foreign Office and the Ministry of Defence. So there is a Whitehall process.
So no one in Number 10 opines?
I mean, I don't recall arms export licenses issues coming to me while I was National Security Advisor. If it's a much more broad general issue like an arms embargo, then certainly the arms embargo on Libya that we introduced in 2011 with a mandatory UN Security Council resolution, that was clearly a matter that came to Number 10. But individual arms export licenses, should we export X or Y equipment to that country, tends to be made in interdepartmental
the Foreign Secretary will have written a letter to the Secretary of State for Department of Business and Trade and copied in the Prime Minister's private secretary. Having
said I've taken legal advice, and my advice is that this is still a legal action, as I understand it. As I say, there is a bit of detail on the process within government that was disclosed in the government submission to the High Court in December, that there is now an international humanitarian law compliance assessment process within the Middle East Department. And the text that was published then, it's clearly not the legal advice, but it shows an indication of the complexity and the difficulty for the government in writing about this. The letter said, advice to the Foreign Secretary, we are satisfied that we do have sufficient information on compliance to inform our overarching view of Israel's compliance with international humanitarian law, that the record of compliance does not reveal a pattern as suggestive of unaddressed underlying systemic weaknesses which might undermine other material pointing towards an ability and willingness to comply with international humanitarian law. That's a pretty formidable sentence.
It is, and I think your argument is there's no way that His Majesty's government could have the information to make that judgment.
Well, to be certain about that, no. Yeah. It is a judgment, I think that's a key word, and clearly the judgment made by Foreign Office lawyers at the moment is that the legal base is there. There's a problem for government, and we've had this in many cases, where the government asserts and rests on legal advice that it has, but then is unwilling to publish that legal advice. It reminds me a little bit of the problems about when the government relies on intelligence, but then says we can't publish the intelligence.
Yeah. I'm going to pause you there because I'm going to bring in Andy MacDonald, who's going to get into some of the mechanics of how these judgments are made.
Chair, I'm just conscious that there is one member of the panel who has actually experience on the ground on these matters.
Yep, and the committee members will put the questions to the witnesses as they choose when they're making their questions. But Mr MacDonald.
Thanks, Chair. If I may, Lord Ricketts, just return to the chronology in terms of advice, because I think yesterday in court it was revealed that the Secretary of State for Business and Trade last reviewed and approved arms sales to Israel on the 8th of April. But on the evidence from that hearing, the government hasn't reviewed whether Israel is committing IHL violations since the 29th of January in the context of export reviews. And it's not received any legal advice on whether Israel is complying with IHL on violations after the 29th of February. this would mean that the Secretary of State for Business hasn't considered any violations or atrocities from the last 3 months in their decision to keep exporting arms to Israel. Given your experience, if there's such a gap in the chronology and the assessment base, is that something that you would think proper in terms of conduct of government?
I assume that the process is a periodic review, and
That's not how it's described. It's actually described as a continuing review.
continuing review. We've had the Foreign Secretary saying in Washington just, I think, last week, as required by the UK's robust arms export regime, I have now reviewed the most recent advice about the situation in Gaza and Israel's conduct. The latest assessment leaves our position on export licenses unchanged.
But if
he
that
doesn't say when that advice was dated.
That's the point. That's
and
the point.
I have no
so if it is
knowledge.
that it hasn't considered any of these alleged violations or atrocities for the last 3 months, given that we're told that it's this ongoing review is on a fortnightly basis, that seems to be entirely inconsistent and unacceptable, does it not?
Well, the Foreign Secretary finished by saying, as ever, we will keep the position under review. And my advice to him would be to certainly keep the position under review and make sure you have the most up-to-date possible analysis on the basis of what's happening,
You'd accept the
including
point that three months ago is not up-to-date? Oh.
Yeah, I would be surprised if the last legal advice they had is 3 months ago, given the intense public controversy about the World Central Kitchen attack and everything that's happened since then.
Okay, if I could just move on, Chair, just looking at the licensing criteria itself, the government says it will not grant a licence for arms exports if it determines that there is a clear risk that the items might be used to commit or facilitate a serious violation of international humanitarian law. I'll pause there because this is a risk-based environment, not an evidence-based environment. And in terms of the facilitation of serious violations, we're not just talking about munitions and bullets and bombs, we're talking about starvation as well. And on the 12th of April, the government referred to a parliamentary statement from 2020 when discussing the question of Israel's compliance with international law. According to this statement, the assessment of clear risk includes, amongst other things, whether a country has genuine intent and capacity to comply with IHL. We hear a lot about capacity, but we don't hear in this place a great deal about intent. And in terms of that obligation to observe international law, it might be worth reminding ourselves of the 4 pillars of military necessity, humanity, distinction and proportionality. So it's an open question, Lord Ricketts and Lord Sumption and Mrs. Hausdorff, but what evidence is there that Israel has a genuine intent and capacity to comply with IHL as part of its Gaza operations? I don't know whether, Lord Sumption, would you like to comment? We'll go that way.
Well, the Geneva Convention of 1949 forbids indiscriminate attacks on civilians, indiscriminate destruction of civilian property, destruction of food, water and other facilities necessary for survival, and imposes an obligation to allow humanitarian relief without limit. Now, those are obligations that, formally speaking, exist only in conflicts between states, which this is not. On the other hand, the same principles are applied as part of customary international humanitarian law. And I think the problem is that the methods used by the Israeli Defense Force are necessarily indiscriminate. Essentially, what they are trying to do is to eliminate a needle in a haystack by destroying the haystack. Each shard of grain in that haystack is a human life. So that I find it very difficult to see on the information available in the public domain how this can be regarded as a proportionate or a discriminate approach.
I think if you look at the evidence of what's been happening in Gaza, Israel has complete control over access to Gaza by land, sea and air. And therefore, it is within Israel's control to facilitate or impede the import of humanitarian aid. We've heard some of the numbers of aid that has been delivered. I don't know how that compares to the counterfactual of what would normally have gone to Gaza before the conflict. But the language of, for example, our own Foreign Secretary or Antony Blinken, the US Secretary of State, has become increasingly exasperated with Israel's blockage of humanitarian aid. The international community have been forced to the extremities of airdropping pallets of aid into Gaza, extremely dangerous process, by the way, since it can kill civilians, and even the US building a pier to allow aid to be delivered because Israel has refused to open Ashdod port or facilitate sea access to Gaza. So the behavior of the Western countries shows that they are indeed feeling that Israel has been blocking access. I've already quoted Lord Cameron as saying it's incredibly frustrating that Israel is not taking the steps to allow more aid into Gaza amid a terrible humanitarian situation. So that's David Cameron's view, and throughout his time since he was appointed, he's been very strong on this point. Israel, as we know, took every step to undermine UNRWA, the UN agency, with a lot of allegations about UNRWA staff being members of Hamas, effectively blocked UNRWA operations in the north of Gaza. The World Central Kitchen withdrew after the attacks on its convoy. So the distribution of the aid that is piling up outside Gaza is itself extremely difficult. No doubt the situation within Gaza to distribute aid is very difficult. So, I think the evidence shows that Israel's allies have been increasingly frustrated that Israel has not been expediting aid at a point when there is famine, risk of famine in Gaza, risk of disease, lack of water and essential supplies and medical facilities. Otherwise, why would the US and UK and other Western leaders have been speaking in the way that they have been?
Forgive me, Mr. MacDonald, you asked specifically about evidence, and I would like to refer to the evidence that I had begun addressing earlier, namely the 449,230 tonnes of aid. It was asked how this compared with previous lorries of humanitarian assistance entering Gaza. It far outstrips the previous. It is also over 3 times the humanitarian provision that the World Food Programme estimates is required to feed the entire population of Gaza. And therefore we must ask ourselves, what is the impediment? Clearly, the 650 lorries that are waiting to be distributed factor into that, but it is also significant that the Fatah authorities have over the last few days been clear that Hamas in Gaza is hijacking aid, is depriving civilians of that aid, is stockpiling it, and is selling excess aid off in the black market at inflated prices. It has also been accused of killing aid workers in an attempt to generate a humanitarian crisis. Why would it do so, you may ask? Because it is plain that Hamas's only aim in the current circumstances is to survive and to drive up international pressure, as it has been doing, and the comments referred to are indicative of that, on Israel to cease its operation in Gaza. That, of course, would enable Hamas to survive and to continue not only to suppress and oppress the Palestinian civilians in Gaza, but also to fire rockets onto the Israeli civilian communities in Israel. That firing continued only yesterday. So that is an important aspect of the evidence that we have, the volume of aid going in and the real reasons as to why there may still be shortages in Gaza. But the references to some of the requirements, legal requirements on aid, are also important to be clear on. It was suggested to you that humanitarian relief is required without limit. That is not correct. Article 23 of the Fourth Geneva Convention is very clear that the requirement to facilitate aid into Gaza is caveated so that it is not diverted to enemy forces. In fact, the requirement doesn't apply where aid cannot be successfully provided without diversion. Nonetheless, as in previous conflicts, Israel is going far above the actual requirements on it.
Yeah, I've got it.
Well, there are a few other matters, if I may. I've come back to the casualty figures ratio. This is critical because it is the basis upon which it seems all of these allegations are being levied. The reason it's important to have an understanding of how badly wrong, fabricated, manipulated the casualty figures are is because it informs necessarily the casualty ratio that we see in Gaza as regards other armed conflicts around the world. Now, the UN statistics put the civilian to combatant ratio on general armed conflict at a very disturbing 9 civilians to every 1 combatant. For the United States authorities, health authorities in Afghanistan and Iraq, it was 3 to 1 and 5 to 1. Even taking into account the false figures that I've addressed, on any account, because Israel...
Colonel Kemp.
Indeed, and I would invite you to do so because he has clear experience of this.
Yeah.
May I just finish this point because it's one I've begun 3 times previously. The casualty figures in this war, in the context of intense urban armed conflict, are unprecedented at around 1 to 1. And that puts the lie to what we have been hearing about indiscriminate strikes or disproportionality, bearing in mind, of course, that it is not an effects-based analysis but intention.
Okay, so there's a tariff of acceptability here in terms of ratios, and you're saying that the 33,000 and rising, as quoted, is inaccurate, and that 2/3 of those figures are women and children, and you do not accept that.
Let's bring in Richard Kemp.
I will. Colonel Kemp, with your significant military experience, I'd really be grateful for your guidance, because we've heard about this issue of proportionality, and indeed the Prime Minister has said that there are too many people have been killed. I've reminded the panel of the 4 principles of IHL with which they're very familiar, but can I ask your opinion as a military operative, if I can, a renowned and decorated one at that, whether the killing of surgeons in hospitals by sniper bullet as they go about their duties, or the dropping of dumb bombs on residential dwellings in pursuit of a military target, is that within the bounds of accessibility and proportionality? Colonel Kemp?
Sorry, I think I got the gist of that. My line is not the best.
Oh, okay.
I should just point out that I've been in Israel for most of the last 6 months, including spending time on the ground in Gaza on several occasions, observing the actions of the IDF. And I'm here effectively as a representative of a kind of think tank called the High-Level Military Group, which is made up of former chiefs of staff and senior military commanders from around the world. And certainly my observations, my direct observations, as well as my analysis of what I've seen in the media and elsewhere, is that Israel is doing all that it possibly can to comply with international humanitarian law in Gaza. And I've witnessed firsthand exactly the way this is done. I could, but I won't spend your time enumerating all of the different measures that the IDF take to prevent the loss of innocent life on a battlefield. But they are, in my own experience, all the different military forces I've been involved with or observed, far in excess of what most other armies are able to do. And I'll give you one brief example of a case when I was inside Gaza attending a command group meeting made up of 3 generals and a number of other officers who were discussing how best to deal with an important Hamas target that was very close to a refugee center there, a school that was being used to house refugees. And these military officers spent 20 minutes out of the hour meeting trying to work out how best to deal with the target while minimizing the loss of civilian life. And I think that's a typical way that the IDF has been operating, quite contrary to what is the perceived perception. Okay. It is, as Lord Ricketts, I think, rightly said, or Lord, I forget, in some ways it is trying to find a needle in a haystack. But the IDF is extremely careful and indeed has lost many of its own soldiers' lives in trying to be very cautious about destroying the other pieces of hay in that haystack before getting to the needle. And I think Natasha's point about casualty numbers is very important. No calculation based on the most recent numbers given by Hamas, which is around about 21,000 civilian casualties, deducting then the IDF's estimate of around 12,000 terrorists killed, leaves something in the region of 9,000 civilians, maybe 10,000 civilians killed in this 6-month conflict, which, when you consider the complexity of this situation with Hamas fighters fighting deliberately from within the civilian population, trying to impel the IDF to kill their own civilians, is, I think, deeply impressive. It's a terrible statistic to have to talk of, but it's deeply impressive and compares, as Natasha has said, very favourably with the casualty rates, civilian to military casualty rates of other other military forces, including the British.
You're repeating the point made, and all of these deaths are so terribly regretted. But given your experience, we see the pictures of devastation in Gaza, the physical destruction of buildings. Is that more consistent with a casualty death rate of 9,000 or over 30,000? What does your experience tell you? And secondly, you, like the members of this panel, will have seen those images on social media of the behaviour of IDF soldiers taking great delight at some of the actions that they've taken, and they have horrified us. Now, that would not be tolerated in the British Army. So why have you got such faith in the IDF to observe those basic principles of international law? I think we're having difficulties with the connection, Chair.
Yeah, I think, again, I got the gist of that. I mean, I have seen some of these images of IDF soldiers delighting in the situation they find themselves in. And of course, that is totally unacceptable. But I would disagree that you wouldn't find that in other armies. Certainly, we've experienced similar problems with our own soldiers in the British Army, as have the Americans. One thing I would say is that when these events occur, the IDF discipline the soldiers concerned. They don't, in my view, represent the overall opinion of the IDF. They don't represent individual soldiers misbehaving, which unfortunately is what you get in an armed force. And indeed, the IDF Military Advocate General a few months ago warned specifically against soldiers making videos of this sort and distributing them, which is deemed to be an offence in the IDF.
Okay, thank you very much. Charlotte Nichols.
Thank you, Chair. We spoke before a bit around the government's application of the strategic export licensing criteria having been the subject to judicial review, and where these decisions have been taken previously in reference to Saudi Arabia during its military operation in Yemen. I'm interested to know from the panel members if you believe that recourse to judicial review is the most appropriate mechanism for challenging licensing decisions, and what other options there should be, if any, either for Parliament itself or for bodies outside Parliament, such as the Campaign Against Arms Trade. If I could start with you, Lord Sumption.
Judicial review has its limitations because it's not the function of the court on judicial review to substitute its own judgment for that of the responsible minister. I think that judicial review has an important place part to play, especially in cases where it is being alleged that the minister has taken a perverse line, but actually by far the most important measure, restriction on government, in my view, is its responsibility to Parliament, and that highlights the significance of the deliberations of your committee.
Ms. Hausdorff, if I come to you next.
I think judicial review is appropriate, but ultimately the check of judicial review is whether the proper process has been followed. Ultimately, the question of whether Israel is complying with its international humanitarian law obligations is one that is best assessed by the executive, and this was made clear by the Divisional Court in the campaign against the arms trade case and its judgment last year. That's because an assessment such as the one we've been discussing involves judgments about targeting, the appropriateness of targeting, which it must be said that the people with the best expertise on those issues reside most likely in the MOD, perhaps also the Foreign Office, and are indeed the officials who have been conducting in conjunction with lawyers the assessments which the government has been relying upon. I would actually highlight paragraph 166 of the Divisional Court's judgment last year, which I think clearly spells out the division of responsibilities. What we have seen, unfortunately, in a number of judicial review applications that have been brought on these issues, is an attempt to put forward a correctness review, as opposed to the proper process of judicial review, which is to assess the process by which government officials and the executive has conducted this. And in that respect, I would draw one example to highlight why it is so important that these assessments are made by experts with access to the closed material, which those bringing these claims simply do not have. And that is because arguments like, when one looks at the physical destruction of buildings, there is only one conclusion that can be drawn as a result, lead to a misinformed basis upon which to draw conclusions and to base analysis. It unfortunately fails to take into account the reasons for such widespread destruction, namely that Hamas in Gaza have been using every second civilian house as part of its terror infrastructure, have been turning mosques, schools and hospitals into terror bases.
I'm trying to keep this just to the judicial review itself.
But that's an example of assessments which are unfortunately conducted without proper information, on the basis often of false information in the public arena, which have clearly informed some of the applications that have been brought. Thus far, I think the court has been dealing with them appropriately and relying on the information provided by government, often unfortunately in closed proceedings. And that leads on to an assessment of whether there is any alternative, and Parliament has been suggested as an alternative. And I think we run into the difficulty here that necessarily these decisions are based on sensitive intelligence that is shared, in this case, of course, by Israel, that would not be perhaps as comfortably shared if the intended purpose was that that information would be provided outside the executive. So unfortunately, judicial review is perhaps the only appropriate mechanism for the kind of analysis that we're considering.
Ricketts?
Well, I disagree on that because I think it's unsatisfactory that a decision should be taken just by the executive on the basis of material that can't be made available to the public in an area which is as important and as sensitive and controversial as this. So I rather agree that I'm sure judicial review has its place, but the real place to hold ministers to account is here in Parliament, because these judgments are all made in a broader context. They all are judgments. They require political judgment of complex facts. And even if all the complex facts can't be made available to Parliament, at least the minister can be held to account for the judgments that he or she has made. That's where we've come to, basically, on issues to do with use of force and going to war, as it were. And we've got to the point where it's now pretty well customary to publish at least a summary of the legal advice. The Iraq War, of course, in the end, the full legal advice was produced, but only 2 years later. And I think in this case, if I can just reinforce the point, I think the role of this committee, particularly in holding ministers to account where they have made judgments, as Lord Cameron has and the Business Secretary in this case for Israel, come here and explain, as far as they can in public, the basis on which they made that judgment. Because in the end, these are political judgments. So I think more parliamentary scrutiny would be right. It's also worth pointing out that the criteria for arms export decisions are now formidably long and complex. They run to many pages, and so making a judgment on them is something that ministers have to do against a very complex background. And I think parliamentary scrutiny of that is probably the best way to give the public confidence that it has been done as well as can be expected in the circumstances.
Thank you. And just to very quickly sort of drill back down into that point, because I think this is really where the crux of what we're trying to work out today is, following the Committee on Arms Export Controls clearly not functioning in the way that Parliament would want it to. So what is the role of this committee, the Foreign Affairs Select Committee, other committees to hold ministers to account for decisions around arms export licences? Because I think Natasha made a very worthwhile point that there are certain things you wouldn't necessarily want entirely in the public domain, but there are still ways of Parliament in closed sessions, perhaps with ministers or other officials, having a greater degree of scrutiny. We've had references made to lawfare and what is the sort of legal versus political distinction of some of these arguments. Do we kind of get ourselves into a territory of arguing about whether or not we can, rather than whether or not we should, make decisions around this, in your view?
Well, ministers in the end have to make decisions and then be accountable to Parliament for them right across the board. That's the way the system operates. And they have to make judgments about how reliable that evidence base is. They risk being taken to court if they do not have a firm legal base for the decision they've taken. But it seems to me that arms export license decisions are no different to many other decisions made in foreign policy, defence policy, national security policy, even intelligence policy. The Intelligence and Security Committee manages to hold ministers to account in an area which is highly sensitive, where much of the information can't be disclosed. But I think the process of parliamentary scrutiny is good.
I could just add this much, Chad. I mean, I agree with what Lord Ricketts has said about this, the centrality of the political judgment involved. But it's not just a political judgment. The whole basis of the export control criteria for the export of arms is essentially a moral judgment about what the United Kingdom should be seen to be doing. And it seems to me that there's a danger of allowing this to be too much taken over by specialised knowledge and expertise, when at the heart of it essentially is a moral judgment, and Parliament preeminently exists to impose upon ministers their collective view as to what morality requires.
I think that there is a danger here, and to a certain extent it seems to me that the answers so far have been somewhat contradictory, in that the criteria, as they've been revised and set out, incorporate the legal considerations, the political considerations, the sensitive diplomatic foreign policy considerations. That is probably why the Divisional Court, paragraph 34 of its judgment last year, highlighted judicial review is not and should not be regarded as politics by other means. Clearly the courts are alive to these issues, the lawfare that you've raised. But to suggest that these are decisions that should be led by purely moral assessments is particularly dangerous, because these are inevitably predicated, as they have been in the public debate so far, by misinformation and by false, inaccurate statements that have been put into the public domain that don't bear scrutiny. It is government that is in a position to properly assess those, because it is provided with the counterfactual and the evidence in this instance from Israel that is plainly either not in the public domain, or that which has been made public is not being given nearly the amplification that the false allegations have been. And therefore, I think the courts so far have been expert in navigating what it is, which is a check on the executive that they are adopting the appropriate process.
Thank you. Jane Hunt and then Andy MacDonald.
Thank you very much, Chair. So this committee is about trade, and I'm going to ask you a specific question about trade, all four of you please, but starting with Lord Ricketts. So do you think that the comment that Lord Sumption made in the very opening remarks is right when he said earlier that in terms of our trade being relatively small, that we need to do what we can, even if that is not a great deal? You said something along those lines earlier on. So is that true, do you think? And also, when is it acceptable to trade in arms? Lord Ricketts.
Well, I think it's acceptable to trade in arms when the arms export licenses meet the criteria set out by the government. And the UK, I think, does £70 billion worth of arms exports a year. And they do that in accordance with the criteria. It's an important part of British industry, creates a lot of jobs, as your committee will be very well aware. So arms exports are not in themselves wrong. The problem comes where the regimes using the arms are potentially going to use them in a way which contravenes their international humanitarian law and therefore our obligations. And we looked at that very carefully over the case of Saudi Arabia, of course, in the Yemen war in 2015, and there was a passage via the High Court in that, and the government went back and revised its criteria for assessing them and then continued. So, I mean, I think that is the well-established process. In the case of Israel, it's true we are not a major arms supplier. I think the total was £42 million for the last recorded year, 2022. I mean, that's set against the many billions that come from the US, including the billions voted yesterday by the Senate. And therefore you could say it's a gesture. I would say that the issue is not so much the volume, it's whether we are comfortable, the government are comfortable that the criteria are being met, and if the criteria are not being met, even if it's only a very small part, then we should have the courage to stand up to our principles and accept that. The point has also been made, of course, that Israel might retaliate against the UK by restricting Israeli arms sales to the UK. I am not clear, actually, the extent of Israeli arms sales to the UK. I've looked at the Israeli websites. They disclose the global totals of Israeli arms sales, but not the individual details, so I don't know that. But in any case, I think if we have a principle, we should stick to our principle. If the government did decide that the international humanitarian law compliance issues were not being met, then they should have the courage to go ahead and suspend the arms sales. For the moment, they haven't done that. But I think that's the policy process that I would see, and the Department of Trade will be agreeing many arms export licenses a year, in line with the criteria, not a rising controversy. And there are just some cases where much closer scrutiny is required.
Thank you very much indeed, Lord Ricketts. Lord Sumption, did I quote you correctly, and are you happy with what Lord Ricketts just said?
Yes, I would have given exactly the same answer as Lord Ricketts has just done from a legal point of view. The arms control criteria, as stated to Parliament, broadly correspond to the international obligations of the UK under international humanitarian law. The question, therefore, is whether we're applying them, not whether we've got the right principles.
Thank you very much. Natasha.
I certainly agree in terms of the application of the criteria and the applicable international law. What would the implications be if, despite the government's assessment so far, consistent also with the United States that Israel is complying with international law, what would the implications be, and what are, in fact, the implications of the sorts of calls for suspension of arms? Well, I think there are significant political and diplomatic ramifications, and we have seen only 2 weekends ago an unprecedented direct attack by Iran on Israel, which many have, I think, correctly suggested has been as a response to the sort of encouragement that Iran has taken from the rhetoric. It was referenced earlier from the United States. It has also in part been coming out of the United Kingdom vis-à-vis the application of international law in Israel's continued operation in Gaza. That has very real consequences for how emboldened Iran has felt. When we bear in mind that its operations so far have been through its proxies, Hamas, Hezbollah, the Houthis in Yemen, and also from proxies in Syria and Iraq, the significant development that we saw of a direct strike against Israel in that fashion is very relevant, and the consequences of the sort of uninformed, unfortunately, debate and calls for suspension of arms, despite those criteria having on no account been met, have very dangerous consequences, I would suggest, also for the UK as a result also.
Okay, thank you.
May I just respond to that?
Yes.
I mean, it seems to me a rather strange argument to make that Iran decided to attack Israel because of arguments made in the US and UK about potential suspension of arms sales. I think a much more likely reason that Iran attacked Israel was because Israel attacked the Iranian consulate in Damascus and killed 13 people in the Iranian consulate in Damascus. If it hadn't done that, I don't think Iran would have attacked Israel.
Well, I think it's
Okay,
very...
forgive me.
Forgive me, I think...
I didn't want to start a
particular
political
line of
argument. I was going to talk about trade.
Yeah.
I do appreciate that, but the committee has just been told something that I'm afraid is untrue.
The committee is perfectly capable of making judgments about the evidence that we receive. Jane, do pursue the question.
Colonel Kemp, please.
Yeah, I mean, the extent of British arms trade to Israel is extremely minor. It amounts to something like less than 0.9% of Israel's total arms imports. And most of that is, we provide no weapons to Israel. As I understand it, we provide only technical components to some systems that can be used for weapons or can be used for dual purposes. And much of that is used in Israeli weapons that are exported to other countries for their own use. So it's very, very minor. On the other hand, the arms imports to Britain from Israel amount to about 2.7% of our total global arms imports. And they do include some very significant military hardware, including tank protection, something called the trophy system. They include anti-aircraft defense systems. They include drones and some other things that are extremely useful for us, for our armed forces. Now, of course, as I think Lord Ricketts said, it would be wrong for us to purely base our decision on exporting arms to Israel on what we get in return. And of course, the decision on exporting arms must be based on all of the criteria that we've been discussing today. But I would say that, as I mentioned before, I've seen absolutely no evidence at all of deliberate breach of international humanitarian law by Israel, and certainly not anything even approaching genocide. We should bear in mind, I believe we have as again, Lord, we have a moral obligation and perhaps a legal obligation to protect countries against genocide under the Genocide Convention. And in this case, we don't have a country, in my estimation, Israel, that is coming anywhere near committing genocide or attempting to, but we do have a country, Israel, that is defending against genocide. On the 7th of October, military forces from Hamas, from Gaza, launched a major operation deploying more troops against Israeli civilians and military than we sent to the Falklands in the Falklands War. It was a very, very significant attack, and Hamas's charter spells out its determination to commit genocide against Jews and Israelis, and its actions do the same, and its leaders have repeated time and again their intention to pursue this. So I believe we do have, unless we can be absolutely certain that there is some kind of that Israel is breaching the law, we should do all we can to support Israel in defending its own people against a genocide against the Jews in Israel.
Okay, again, this is about trade, but thank you very much indeed.
I'm going to speed through a balance of questions, but Mr. MacDonald?
Thank you, Chair. Just going back to this business of the relatively small amount of exports going to Israel from this country, 42 million, £104 worth of 2022, 114 standard individual export licences. But Lord Ricketts, Lockheed Martin is the lead contractor for the F-35, and that's built through an international coalition with 15% of the value of all 50 F-35s made in Britain. And Lockheed Martin themselves said the fingerprints of British ingenuity can be found on dozens of the aircraft's key components. Now, the intellectual property may have gone, but isn't there still that obligation upon the United Kingdom to, with reference to that significant contribution, to think about steps, even though it may not have a particular impact now, to demonstrate that commitment? It may be beyond a demonstration, but in concert with the moral obligations of this country. Isn't that a valid argument to make?
If I understand your argument, you're saying that the UK should be prepared to take a view on how F-35s have performed, how they're used, after we've supplied components for them, after they've been delivered by Lockheed Martin to third countries. I mean, that gets us into pretty difficult territory, I think, because there will be British components in very many armed systems around the world, many made by the US. And I think the capacity of the UK to dictate how a weapon is used that has some components from the UK in it is quite limited, actually. So I'm not sure that that's going to take us very far.
Is there any obligation, perhaps Lord Sumption, upon us to acknowledging the contribution that we've made to the facilitation here, to take steps in response, and be that suspension of arms sales or something more nuanced short of such a suspension?
Well, legally, we have to do what we can. We are not required to do things that are likely to have no or negligible impact, but we are required to do what we reasonably can, and that includes assessing the effect that our decisions may have on other people who supply arms to Israel.
And Ms. Hausdorff, am I right in assuming that you think we shouldn't even trespass anywhere near these issues of arms suspensions?
Well, these matters are under consideration, but again, the concern is that this analysis and even this discussion is being conducted on a false premise, which is that Israel is breaking international law. Morality has been mentioned a number of times around this discussion, and it is significant, the point that Colonel Kemp makes, that there is an entity that has been subject to acts of genocide by Nukhba forces, the Hamas terrorists and other terrorists that crossed the border on the 7th of October. If we are to talk about the UK's moral approach and the moral imperative under the Genocide Convention and the responsibility that we have to prevent and punish genocide, then the balance weighs entirely in favour of the acts of genocide that are indisputable, that have been documented by Hamas on GoPros and that have been promised by their leadership again and again. And so the balance of morality falls squarely where the balance of law, politics and diplomacy have, and that is continuing to support Israel as an ally of the United Kingdom in this fight against genocide.
Thank you. I'm going to move us on, if that's okay, unless you've got...
It was just simply this.
Brief.
I just wanted to ask Lord Sumption whether whether he would agree that if we're to make these judgments in this place, that we're going to be better served if we have sight of government's legal advice, albeit redacted in terms of those matters that are going to cause difficulties. But surely, if we're to make an informed statement or come to a judgment in this place, we should have sight of it, should we not?
Well, I entirely agree. I mean, I have expressed my own view of the law, which is based on pretty careful study of the legal materials. But I'd be the first to accept that lawyers are not infallible and that another point of view would helpfully inform not only the committee, but those like me who have expressed opinions on the subject.
Witnesses have been very patient with us, but I am going to speed us up. Mr. Lavery.
Thanks. Before I asked Colonel Kemp a question, I'm just perplexed ever so slightly with Ms. Hausdorff's contributions this morning. She said there's been a raft of false information, there's been extreme inaccuracies, there's been mixed premise, there's been misinformation, there's been false information, there's been factually incorrect information, there's been untrue information, and there's been information given on a false premise. And I think that's just a smattering of what's being said this morning. Might she give this committee some advice on who would be best to give non-partisan, authoritative, inaccurate voices on this issue?
Well, the detailed response document that I've submitted to the committee goes through on the basis of open source information, dealing with the inaccuracies that have been presented in the open correspondence to the Prime Minister, referred to as the Gaza letters. And I would refer the committee to that analysis. Other than that, of course, it is the government, the executive, that is in the best position to draw these conclusions on the basis of the advice that it has been given, because, as we have previously addressed, of the information that is provided, to it. And that is, in this instance, provided by Israel directly, intelligence, closed information that courts have previously considered in the Saudi Arabia case, provided by Saudi Arabia. Unfortunately, and it did seem that the Gaza letters were encouraging a change of policy by the government predicated on that false information. If that is to be taken into account in any respect by the committee, then I would encourage it to consult that detailed response document carefully to understand where it is deeply misleading.
Colonel Kemp, what would your response be to the suggestion that a reciprocal move by Israel against the UK following a potential ban of UK arms exports would there be much more that would be much more significant because of the impact UK-Israel defence cooperation and intelligence sharing might have. What would your view be of that?
Yeah, I mentioned in my last answer the difference, the significant difference that in arms trade between Israel and the UK, and we are, I would say, in terms of military effect, we are certainly beneficiaries of that, and our armed forces that are supplied to us and Israeli technology. And I think if we were to cease arms trade with Israel, we would be, and they were to reciprocate, then we would undoubtedly be the losers in that. In intelligence terms, I'm somewhat out of date because it's been a number of years since I worked for the Joint Intelligence Committee. But in my capacity there, I was well aware of very, very close intelligence relationships between Israel and the United Kingdom, from which the UK and Israel both benefited. And certainly from my understanding from media reports in recent years, many, many British lives have been saved by Israeli intelligence, both here in the United Kingdom and in places like Afghanistan and Iraq. And so I think if an international dispute between the UK and Israel developed into Israel considering ceasing providing intelligence to us, I think we would be at a huge disadvantage, and potentially there would be loss of British lives. But from my knowledge of the way that the Israeli government and the Israeli intelligence services operate, I think even if there was a real breakdown in relations between Britain and the UK, it's highly unlikely that Israel would cut off intelligence sharing with the UK. And indeed, they share very, very important intelligence with a number of other countries that are even considered their enemies around the world. So I think there would be a negative impact for us, but I don't believe it would extend to a breakdown of intelligence sharing.
Do you agree with that?
Yes, I agree with Colonel Kemp on that. I think it's uncomfortable to make the argument that we could not think of applying the criteria in our own arms export licensing because of concerns about the reciprocal implications from the other country. But what Colonel Kemp says is just an example of the complexity of the decisions that ministers have to make. It's even longer ago, Colonel Kemp, that I chaired the Joint Intelligence Committee and was NSA, but I endorse what you say about the importance of UK-Israeli intelligence cooperation, and I also agree with you that it would be unlikely to be put at risk, particularly where it came to risk of life intelligence from a political dispute about supply of a relatively small amount of arms. However, it's another reason for having parliamentary scrutiny of these very difficult decisions.
Thank you. Charlotte Nichols.
Thank you, Chair. Export controls can be regarded as national security tools, for example, in terms of non-proliferation, also foreign policy and diplomacy and international trade. And again, we come back to this discussion around, what the UK can do versus what it should do. And I note in the letter from UK Lawyers for Israel, for example, from the 8th of April 2024, it stated that the UK had no obligation under international law to, and then continues. So again, we're into this space of what the UK is obliged to do versus, what we can take the decision to do. And I'm interested in drawing out some of that distinction more. Lord Ricketts, during your tenure as National Security Advisor, did these export control discussions cross your desk? And again, where was the balance in the decision making between what the UK is able to do, what it's obliged to do, and what the UK might choose to do for other considerations, political versus legal, for example?
I don't recall in my time as National Security Advisor 2010 to 2012 individual arms export license decisions coming to me and to the Prime Minister. Perhaps there weren't any particularly controversial ones at that time, but they were, I think, handled through the routine that we've talked about of Trade Secretary consulting Foreign and Defence Secretaries. What the issue that did come was the UN arms embargo on Libya, at the time of the Libya conflict, which was authorised by several UN Security Council resolutions. But that's a bit different to individuals. It does show that the issue of arms exports is a national security tool that can be deployed. Embargoes are often applied, of course they're applied in a number of countries at the moment. Just one point, which again is useful when the committee comes to scrutinising these things. In the case of Libya, it was a very comprehensive arms embargo resolution. When we found that the situation changed in Libya, that there was a new regime came in, the National Transitional Council, and we needed to be able to supply personal arms to UN staff and humanitarian staff, we had to go back and change the resolution because it ruled out any supply of any arms in any circumstances to anyone in Libya. So the framing of the resolutions can need adaptation. But individual arms export licenses, in my experience, it's rare that they would get to the level of the Prime Minister and the National Security Council.
Thank you. Natasha, back on this point, the discussion has been around whether the UK is obliged to suspend arms sales in many respects, but we're not. I suppose the counter-argument is that we're not obliged to trade with them either. So where would you put the balance there?
So the UK LFI response dealt with the question of a legal obligation, because what the first letter had put forward to the Prime Minister was that the UK had a legal obligation to suspend. And that was incorrect, not least because of the initial discussion we had on the question of plausibility, but also under, for example, the UN Security Council resolution that was being advanced, which formed a political resolution, not a legal one. So there is no legal obligation. It then comes to a consideration of all of the issues that have been addressed so far to do with Israel and its supporting a war that it is fighting against Iranian proxies. And the UK has not just done so in the context of the arms that it has been, the cooperation we've already heard about, the very limited export from here, but also in the context of what we saw the RAF being deployed to defend Israel against Iran's direct strikes some 2 weeks ago. And all of this certainly comes into play because it's important to factor in that this is not just a war that Israel is fighting against Iranian proxies on its own behalf, but it is on behalf of Western liberal democracies like the United Kingdom and like the United States. And the aid package that was referenced, that was passed by an enormous majority yesterday in Congress, is also indicative that the United States recognises, despite some of the troubling rhetoric that we've heard, which is out of sync with the updates that we've had from COGAT, the unit of the IDF that is its sole purpose is to provide for humanitarian assistance for civilians. Despite the fact that we've had some of this concerning rhetoric, the position that has been adopted has been robustly to support Israel, not just fighting the genocide that was referenced earlier, but also on our own behalves, because Iran and its proxies make it clear that while they are starting with Israel, they don't intend to end there. So if we're looking outside of the legal obligations as to the balance of the United Kingdom's interests, then the answers on that, I would respectfully submit, are pretty clear also.
Lord Ricketts, do you think that we could use our export controls in a more strategic, advantageous way, outside of, again, the legal argument about whether we can? Again, I'm back into the should argument, I suppose.
Well, I think the debate we've had for the last 2 hours shows the difficulty of using arms export licenses as a political tool or a strategic tool, to use your word. In the end, it is essentially a political judgment made on the basis of legal evidence, and I think it's best to leave it like that. I mean, you're right that the whole issue of arms sales is part of the foreign policy of the UK towards a particular country. For many years it was very controversial with Saudi Arabia. There were great concerns about what Saudi Arabia was doing in Yemen, and then a few years later we find that the UK is part of a coalition striking Houthi targets in Yemen because the Yemeni militias are attacking shipping. So it's a very, very complex world. Things do change. I think it's best to leave arms export licensing where it is as a political judgment made on legal criteria as best as ministers can, and subject to debate and scrutiny and challenge in Parliament, if necessary in the court. and not try and use it for wider leverage purposes, which I think gets more and more difficult.
Thank you. Lord Sumption, anything you'd like to add?
The obligation legally is to do what we can. That undoubtedly leaves a margin of judgment to the UK as to what the best way of doing this is. But it's clear that they are obliged to do something. And arms sales have this special feature, which is not present in other kinds of sanctions, which is that they are concerned with material that is directly being applied in the military policies that, at least arguably, and I think very probably, break international humanitarian law.
Thank you.
Mr. Higginbotham.
Thank you, Chair. I want to follow up on some points that Charlotte Nichols and actually Andy MacDonald were talking about earlier, and then I'll move to another point. And this is on this strategic approach to arms exports and whether there's any risk there. And Lord Ricketts, I'll address it to you if that's okay, because I think it's probably most pertinent to your experience. When we were discussing earlier, and Andy MacDonald mentioned it about this, the F-35, and it's got component parts made here in the UK, and we were talking about the difficulties we would have if we were to try and extrapolate from that end use. I was reminded of a case with Germany a year or so ago on the export of Typhoon to Saudi Arabia, I think it was. Is there a danger if we go down that route and apply more discretion rather than the published criteria, we become a less reliable partner when we're trying to come up with international consortiums to do some of these things that we just can't do on our own?
Well, I think you raise a very important point, because as arms become more and more complex and more expensive, it's going to be more and more the case that they are produced by consortia of countries. And the Typhoon example is a very good one. There are others in the land vehicle area as well, I think. And I would not want to see a position where the UK routinely took a different position from its allies on how weapons that include UK components could be used. I think it's important that we have a collective approach to that. So I think that you're right to highlight the point, but if you are going to join a consortium of countries who manufacture an advanced weapon, you have to have confidence, I think, among your partners in their arms export policies, so that you don't find that the arms that include some of your components have been delivered to countries whose human rights record, international humanitarian law record is bad. And I think we discovered that Germany's tolerance level was probably, whatever it is, higher or lower. I mean, they were more sensitive to the use of the Typhoon aircraft than perhaps the US and the UK and other members of the coalition were. I think you've got to have a hard-headed, pragmatic judgment and base your coalitions of producers on judgment and trust that countries will have a similar approach to arms exports as we do. And I think that's largely been the case. I mean, we've been involved in many collaborative arms export or arms development projects over the years. Many of them have been exported, and the cases where we've had serious difficulties with our partners has been very, very limited. So it's an important issue of principle. I think in practice, it's capable of being resolved.
When you say limited number of examples where it's been a problem, is that because we try and anticipate it very early on, or is it because we only really come up with programs with allies that are of such a strategic nature that we can broadly get it, or is it something? And how do we do that moving forwards?
Yeah, I think the allies who we work with on the major weapon systems tend to be either the US or some combination of European countries, the French, the Germans, the Italians for fighter aircraft. I think in practice it's largely been the case that we've had a similar approach to who we are willing to supply those arms to. Germany had a lower tolerance, particularly for Saudi Arabia. The UK and France have tended to see very much eye to eye. For example, we've taken the same approach to the supply of Storm Shadow, or as the French call it, Scalp, to Ukraine. Highly sensitive decision, but the UK and France have had no difficulty, I think, taking that together. So, yeah, I think it's because we ally with countries to make these advanced systems where we have confidence that they'll have a similar approach to exporting. That will be more and more the case in the future, because more and more of these platforms will have to be exported in order to be viable.
Thank you. I'll move on to my next topic. We mentioned it very briefly earlier, but earlier this month we saw a direct attack from Iran onto the state of Israel. I'm going to ask each of you whether it has changed your position, whether you've reflected on what was in your original letters or original positions. And I'm particularly mindful of the comments from the Foreign Secretary that he made a couple of weeks ago, where he said imposing an arms embargo on Israel would have looked ridiculous in light of the Iran attack. I just wonder what your reflections are, particularly because I'm looking at the licenses we've granted for export of items, and Colonel Kemp, you're right, most of it is component parts. The biggest component part, from what I can see, is for military radars, which one would assume have played quite an important part of Israel responding to that attack. Lord Ricketts, I'll start with you again.
Well, I don't think it's changed my mind. No, I still think it's right that we should apply the criteria we've set out rigorously. Is that for you or for us?
Just opening prayers.
Okay. I think we should apply the criteria rigorously. I don't personally think it's ridiculous to have taken that position in the light of the concerns that I and others have expressed in Gaza, and then find that when Israel was attacked, the UK had capabilities in the region. We were part of an existing operation overflying Iraq and Syria, Operation Shader. We were in a position to support Israel in its right of self-defense, and we did so. I don't find those two positions incompatible at all, actually.
Lord Sumption, if I'm to you now.
Neither do I. The Iran attack has not made any difference to the views that I signed up to in that letter, essentially because I don't think anybody denies the right of Israel to take steps for its own protection. The problem really is the methods and the indiscriminate quality of the way that they have responded. And that seems to me to be a factor that's completely unaffected by the fact that Israel is itself under attack from another quarter, namely Iran.
Natasha?
I think it's very interesting that we have seen such a focus on 330 drones, cruise and ballistic missiles launched directly at Israel last week, but the 12,000 rockets fired at Israel over the last 6 months have seemingly escaped public notice. That is 9,100 from Gaza, targeting civilians in Israel, 3,100 from Lebanon by Hezbollah, targeting civilians in Israel, 35 from Syria, all targeting civilians in Israel. So no, the Iran strike has certainly not changed the opinion, I think, of those who have been aware for a long time of the Iranian regime's genocidal intent to destroy Israel. In respect to the previous reference that this was a response to a 1st of April attack, it's important for the record to note that the alleged strike by Israel on the 1st of April, which is not one that it has acknowledged, was not against a consulate, but a building next to it. Anyone who has seen images from the ground will note that the consulate remains intact. It was an annex, which by all accounts was being used by very senior IRGC generals to continue to orchestrate the attacks that I've just outlined against Israel. In that respect, the Prime Minister's remarks are interesting because there has not been a significant change in the approach that Iran has taken, rather than relying only on its proxies for its genocidal war against Israel. It has taken the opportunity to engage directly, and as I said earlier, there are many that argue that that is a result of the very concerning rhetoric against Israel, which has served to encourage. I have said Iran, and I must apologise and clarify that it is the Islamic regime and not, of course, the Iranian people who are subject to just the same oppression and brutalisation, unfortunately, that the Palestinians have been suffering under Hamas in Gaza.
Thank you. And Colonel Kemp, if I could come to you, you will have much better knowledge of the countermeasure systems used to repel that Iranian attack. If there wasn't an expert of radar components, would it have made a difference?
Yeah, I mean, a key element of repulsing that attack was, of course, detection of the missiles in the air, which enabled British, American, French and Jordanian as well as Israeli countermeasures against it. And so those radar components, I don't know whether they were our specific radar components were used, but they would have almost certainly made a contribution to that. As far as the same goes also, of course, for our components that we provide for the F-35 aircraft, which were used by the Israelis in repulsing the attack and, as I understand it, in making their very limited reply to that attack. But I think one thing we might want to observe is that our participation, both in providing components but also in flying RAF aircraft in defence of Israel, was not only noted by Israel but also by the Arab countries in the region. And I think our standing would have increased among Arab nations as a result of that, because, of course, they have deep fear of Iran as well as fear of Hamas. And, their countries are among the greatest cheerleaders for Israel in the war in Gaza, because they understand that Hamas, as an Iranian proxy, endangers them as well. So I think it's it certainly didn't change my perception of this whole picture. But if anything, I think it increased British prestige.
Okay. Thank you. That concludes. Thank you very much indeed to everybody for your patience. We've run for nearly 2 hours, and you have provided your evidence in a really calm, methodical and forensic way, and we are incredibly grateful to you. You've done a great service to Parliament as we try and ensure that the House is well informed on the arguments in this debate. We would be really grateful if, on reflection after this panel, you would feel free to supply us with any further written information about points that you didn't feel that you got across, or observations on other evidence that you've heard. And we will go forward to ensure that much of this material is then used in our accountability sessions with ministers. But that concludes this panel with the committee's thanks. Order, order.
The proceeding is currently suspended. 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 The proceeding is currently suspended.
5-4.
Order. Welcome to the second panel on the committee's inquiry into arms exports to Israel. Today we had very much hoped that we would be able to hear from ministers in the Department for Business and Trade and in the Foreign Office. As the committee knows, we invited ministers 20 days ago, and this was the first hearing after recess that we were asking ministers to come and join us. We did not hear from ministers over the course of Easter. We therefore chased both departments last week and received a reply on Friday that they were not able to be with us today despite 20 days' notice. I have, however, received a message from the Deputy Foreign Secretary this morning apologising for his department and making clear that the Foreign Office will participate at the earliest opportunity. I have to tell the committee that, to my regret, we have not had any messages from the Department for Business and Trade, which of course has policy responsibility for arms exports strategic licences. There are a number of questions which have emerged from our evidence that we would have put to ministers. For example, how do ministers interpret the ICJ's rulings on plausibility? And what would the implications be for strategic export controls? What is both the evidence and the reasoning behind the judgments that have been made about whether Israel has the intent and the capacity to comply with international humanitarian law? The last legal assessment, as we heard, appears to have been at some point in December after the court filings that were published from the 8th of December. but the Secretary of State decided to keep open licences on the 18th of December, but we don't know what subsequent assessments or judgments have been made. We don't know what assessments have been made since events of the 9th of April. We don't know why just two factors, intent and capacity, and not others, are considered when judgments are made about whether a clear risk is present. We don't know whether real-world outcomes could or should be considered. We don't know whether ministers are aware either of negligence or patterns of non-compliance or a lack of commitment that might undermine the judgments that they have made. We don't know what examples they've considered. We don't know what examples they have dismissed in their reasoning. We're not clear about who is amongst the decision takers, and we don't quite know what role is played by the Attorney General or Number 10. We don't know yet definitively whether we can see the legal advice. There is a precedent for publishing legal advice in 2018 on the EU withdrawal agreement and in relation to action in Syria. And finally, we have to note that close allies like Canada and Japan and Spain and Australia have made different judgments to us. They have not kept their open licences open, and we need to know why our ministers have made different decisions. So those would have been the questions that we would have put to ministers, amongst others, but they are not with us today. And so, in line with the guidance of the Deputy Speaker yesterday, I will raise this question with the Leader of the House tomorrow at Business Questions. I'm afraid that concludes this panel. Order. Order.
The proceeding has ended. The proceeding has ended. The proceeding has ended. The proceeding has ended. The proceeding